Thanks, Jennifer. Jamie.
So good morning, everybody. I'm a lawyer here in Vancouver. I work at Ferris, and I advise generally on various aspects of transactional law, corporate commercial law, and real estate law. And I advise also the BC Standard or BCREA Standard Forms Committee. So that is what I'm doing here today, to sort of support and to provide legal backup and advice on this presentation.
Great, thanks, Jamie. So I'm Karin Caldwell. I'm the Chief Operating Officer with BCREA. I've been with the organization around 7 years now. I started as the CFO and took on my role as COO about 2 years ago now. And part of my portfolio includes standard forms. So today we put together a webinar for you that's largely going to cover the areas of standard forms, disclosures, and contracts that you really need to be aware of in the midst of COVID-19. There's certainly challenging times out there, and we've been incredibly impressed with managing brokers and realtors that are really showing resilience and ingenuity and ongoing leadership within the profession. So in terms of some housekeeping for this morning, we are going to go through a series of questions that we've been hearing of. We'll be giving you some answers around that. And then we will open it up to questions afterwards. So we will ask you to use the chat function with any questions. And when we open it up to Q&A, we will ask you to unmute your mics and ask your questions and have some conversation. So BCREA is here to help through COVID-19 as well as your everyday business. We do have a community of practice for managing brokers that happens every Wednesday. We've actually just finished it. It's from 10 to 11 each Wednesday. We have a COVID-19 portal, which has a whole series of blog posts and other resources, anything to do with financial aid, conducting transactions, standard forms and liability, economic forecasting, as well as supporting your clients. If you haven't seen that already, please head to our website. At the end of this presentation, I will put a slide up that has the link to it as well for you. We have regular podcasts that are available as well with different speakers. At the moment, it's specific to COVID-19, but it will open out as we move beyond this pandemic. We're also offering PDP savings for all of our online learning opportunities, and that is a 25% savings. So feel free to take advantage of that. That's over the next 3 months, May, June, July. And our GR advocacy team continues to do a lot of work with the government and really understanding how the measures that are being put into place impact realtors and managing brokers, and making sure that we're not falling through the cracks on some of the initiatives that are there. So today's content is BC specific, and Jennifer and myself are always available. If we don't get to your questions today, please feel free to reach out and we'll make sure that we do that. And we can also include any additional questions into the resources that are available online. So with that, our agenda for today, we're going to start with the formal question period, where I'll be asking Jamie and Jennifer a number of questions that we've received, giving you some thoughts from both the managing broker perspective as well as the realtor perspective. We will open it up to a Q&A after that. And the themes are going to cover anything from practice as an essential service, the notice and acknowledgement form that was released a couple of weeks ago, liability, COVID's impact on contracts, privacy law as it impacts our new normal, and really starting to talk about these topics in the context of the regulations softening going forward. So just a reminder, our purpose here today is not to provide legal advice, and we do recommend that you obtain legal advice relevant to your unique circumstances. And once again, any topics that we don't cover, we will refer you to the website, or you can contact myself or Jennifer. So with that, I'm going to hand it over to my colleagues here with what does being an essential service mean to our everyday operations. We know that we've been designated as an essential service. The BCREA advocacy team has worked really hard to get that to be the case. But what does it actually mean? Jennifer, would you like to share your thoughts?
Absolutely. So definitely that was a significant announcement. It means that it's not business as usual. So while government included real estate as an essential service, allowing for real estate sales to continue, this was definitely not a return to business as normal or what we were used to. The liability order, which we're going to touch on a little bit later on in the presentation, was a significant announcement in that it provided some realtors that they couldn't be held liable for damages resulting directly or indirectly from someone who was exposed to COVID. And so it provided some assurances for realtors as long as they were practicing following the proper guidelines and orders. Again, in ensuring that they are protected, realtors have to follow those provincial guidelines, so keeping up to date as these things change is definitely paramount. And while we were deemed essential in terms of the transaction, there was no definition or prescription as to what can and can't be done. And BCREA and councils got together, they put out a communications on principles practices, and these principles don't change. So they're not related to COVID or COVID over time, but they really are based on the principles of practice. There was definitely, it's really up to realtors and managing brokers to understand what does practice look like under the essential order. It's also important to remember that the rules haven't changed. So while real estate is deemed an essential services, the rules are still in effect.
Sorry, Jennifer, if I can just jump in for a quick second here. The individual, Enrique Romero, who is showing your screen, can you please stop sharing? That would be great. Sorry, Jennifer, go ahead.
No, thanks. I was going to just turn it over to Jamie for a legal perspective, and that would be great if we could get the screen, the stop sharing done.
Well, as Jennifer's said, really it's not business as usual. And so it's really important to speak with your clients about this and just have open communication to explain what the real estate process is going to look like now in this COVID response and in the COVID world. So to that end, BCREA has provided a notice and acknowledgement form. And this is really a tool that is available to help guide the conversation, or at least start that conversation with the client. It gives them notice that they're aware of that it is not business as usual right now. And it also advises that, before signing any documents that have obligations on the client, they should be getting legal advice to understand how things may be different now that there is COVID or there are COVID risks out there and things are changing. So really, this is a document that helps you support your practice by teaching clients and talking to clients about these risks, and it promotes protection for them as well. And as I say, the big thing there is it also advises them to get legal advice before taking on obligations that could be affected by COVID-related matters.
Absolutely. Jamie, I think as you pointed out, with the listing and the contract of purchase and sale, really didn't contemplate the unique situations that would arise under COVID. So the communications with clients is absolutely critical. Communications has always been a fundamental aspect of real estate services and what we provide, but probably now more than ever before, we can see issues arising when there is a gap between what the clients expect and what you can deliver. So the notice and acknowledgement form, as Jamie had suggested, it not only protects the client's interests in helping them make informed decisions, but it also helps meet council's recommendations on having fulsome discussions and documenting the same. This includes advising the parties to seek legal advice early to address the issues if and when they arise, but doing so early on. Scripting these discussions might be valuable in terms of ensuring that there's consistency in the messaging as well.
Thanks, Jennifer. The other piece that BCREA is very concerned with is around reputational risk. BCREA is really concerned with the profession as a whole, and specifically within BC's borders, but it does go beyond that. So a lot of what we put resources out on and a lot of our work around professionalism is really trying to manage the risk of reputation. And that the difficulty around reputation is that it comes because you've done something, or it comes because you're perceived to do something. So that really gets into some of the practice considerations that maybe, Jennifer, you can explore a little bit more.
Absolutely. One of the things that the reputation of the profession is that's so important for is advocacy and being able to have that voice. And so part of our protection of that reputation is so that we do have a strong voice and that real estate is heard in British Columbia. So, but in terms of the operations, BCREA nor the local boards can prescribe the operating procedures. This is largely a decision that has to be made with brokerages and realtors as to what services are they going to provide and what does that look like. So we have definitely seen the profession very quick to adapt their businesses to look at virtual realities and alternatives to help facilitate clients in a real estate transaction instead of meeting face-to-face, and that was very significant. I think with that, Ted, the profession, like many other entities, is under significant public scrutiny right now. And so I've got a few examples of things where, you know, we've had some media on that just to bring it to light. Definitely, we saw public commentary on realtors holding open houses, and there was a recommendation that came down from BCREA asking face-to-face interactions to be limited. And council stepped up and backed that recommendation as well. And we haven't seen many since, but there's still a few, and they definitely do make the newspaper when they're hosted. So more recently, within the profession itself, we've had realtors questioning other realtors on some advertising around COVID-19, a virus-free house. And these can be deemed to be false or misleading statements because unless they can be supported by evidence. So again, we just would encourage the profession to think carefully before making or allowing clients to make such representations, because it can definitely tarnish the reputation as a whole. We've recently been hearing of tenants saying that realtors are ignoring orders in terms of requesting showings. And I think this is where sometimes perception may become a reality for some people, or these are perceptions rather than facts. But what realtors can still request showings, but it's important to consider how that might be perceived. So maybe ensuring that those requests are grounded in a clear understanding of what those orders are, the tenant's rights, and making the requests that are coming on behalf of the clients. So really grounding that information to make sure it's really well understood. The other topic of interest is definitely waivers and whose interests are they protecting? As realtors, you have a fiduciary duty to work in your client's best interest, and some of those waivers may not be in the client's best interest, and I'm not saying that they all aren't or anything of that nature, but really contemplating when looking at the use of waivers, is this in my client's best interest or am I protecting my interests? So really critically thinking about that balance. I would say that this is a time where over-communication can only help resolve some of these perceptions, so would definitely encourage realtors to be constantly communicating with clients, which I know for the most part they are doing.
And that's a great point, Jennifer. When we're going through this pandemic, we're all feeling that we're not sure what's happening and what's coming next. And there does seem to be a certain amount of jumping to conclusions happening out there. So the more that realtors, managing brokers can have those conversations with your clients and with others who may be perceiving what's happening out there, the easier it is to overcome some of those reputational risks. So Jennifer, you touched a little bit earlier on the ministerial liability order. Um, if we talk a little bit more around what does that mean and how does this impact the use of waivers? So I'm sure that everybody's aware that the Solicitor General on April 2nd issued a liability order where a realtor can't liable for damages resulting directly or indirectly from someone being or likely being infected with or exposed to COVID-19 as a result of a realtor providing real estate services in accordance with all applicable emergency and public health guidance. So all of that to say that if you're following all the guidelines designated as an essential service, you can't be held liable for damages. And there seems to be some confusion out there as to what does that actually mean? And what do we need to know as a result of that? Would you like to share your thoughts on that?
Absolutely. I think we need to take the conversation back and start with E&O and what the coverage was, because there was a lot of misunderstanding about what E&O covers and what they didn't. And so I think if we can start back with sort of some statements that came out and some concerns that realtors had, and then how it evolved to the liability order, I think that it's important. So E&O has never, it wasn't because of COVID. They've just never, ever covered claims that related to sickness or diseases. So while you're not covered under E&O, if a client were to contract COVID, you do have protections under the liability order, which was so significant because it sort of provided realtors with some assurances that provided, as you said, Karen, that they followed the guidelines and the orders, that they had a level of protection. And I think that that's where realtors started really contemplating about how they were going to set up their business and what they were going to do and the measures they were going to take. I do want to touch on E&O, and what it does cover and continues to do is it covers for claims for errors, omissions, or negligent acts in the course of providing real estate services. With that said, it doesn't cover for negligence or inappropriately using tools in a transaction itself. So right now, what we are very aware of and thinking about is the virtual tours of where clients have never seen a property and the risks associated with that. And if there was negligence with that, you may not have E&O insurance. But I'd like to invite Jamie to speak on sort of the use of waivers and you know, whether waivers are still required now that we have this liability order, or what his thoughts are on that.
Thanks. So we saw a number of waivers and a number of sort of standard boilerplate type clauses that started to pop up in both service agreements and in contracts of purchase and sale quite shortly after sort of everybody locked down and there were issues and before the liability order came out. And that was the initial response. And looking at a lot of those waivers, a lot of them were covering the same types of issues that the liability order has been put in place to protect. So in those cases, the waivers probably aren't needed as much anymore because the order provides the protections that realtors and others were out to obtain. But as Jennifer's talked about here, there are times when you might be looking to get protections from more than what the order covers. And in those cases, possibly a waiver might still be appropriate, or similarly, a standard clause or some kind of a clause put into an agreement could be appropriate. We just have to remember what the liability order covers, and it's protection from someone being infected or potentially infected in the course of providing the essential service, so long as there's that provision is following public health orders and that it is not done in a grossly negligent manner. So just keeping that in mind, we now look at what we're trying to cover if there's additional waivers that we're trying to get. A lot of people said to BCREA, why don't we have a standard form waiver or a standard form clause that we could provide? And we did look at that, but the biggest issue that we found was that there really is no one-size-fits-all approach to these, because every situation is going to be slightly different. The other issue that we ran into was parties have different competing interests, and so a buyer's interests may not be the same as a seller's interest, and they may not be the same as a realtor's interest. So BCREA's advice from the beginning has been you really need to create clauses or waivers if appropriate, and based on your situation. So that the key there is to get legal advice for specific situations that you're trying to cover before you go in and just start using a clause that may not be appropriate. The problem there might be that you run into an issue where if it's not appropriate, you've not actually protected what you're trying to or that you've set up, what you've set up to protect. Similarly, if you are receiving a waiver, say you're attending an open house, for example, with a client, or attending a virtual open house even, and you receive a waiver from another realtor, or your client receives a waiver, or they try to put a clause in, I would say that the best advice there, again, is to consider what is being asked of you or your client. And before just signing right away, think about the implications and get legal advice if needed, or if you think it's necessary, or if it's not clear. Because what the effect of the waiver is it's limiting your ability or your client's ability to obtain damages of any sort if they otherwise would have been able to, or if something comes up. The other thing to keep in mind is just because you have a waiver doesn't mean that you are necessarily off the hook on professional liability and regulatory matters. So really, it all comes back to being careful and taking reasonable steps as you proceed with your day-to-day practices. And also, again, coming back to communicating. Over-communicating is better in this situation, and set expectations early with your clients, with other realtors, and with other parties as you're going forward. The last point I'll talk about on this area is that it goes back to the notice and acknowledgement form that we've provided. This has been available as a tool that'll help you have these conversations early on and start the process and the thought process rather of speaking with a lawyer for you and your clients.
Thanks, Jamie. There's been a couple of questions just come up in the chat here that I think it makes most sense to ask them now. For those that are outside of BC, are there similar liability orders in other provinces? And Jamie, I'm not sure if you'll know that given that we're Vancouver based, but I'll ask the question just in case.
Yeah, I'm not sure if that's the case. I think you'd have to speak with someone in it looks like you're in Ontario, that question. So just I'd speak with a lawyer in Ontario and see if you can get the right answers on that one.
Your professional association, so ORIA, may have that information for you as well. Jamie, would you like to comment as well on Arnold's comments around the order?
Yeah, I'm just reading that now.
For those of you who haven't read it, it says, just to clarify, the order may protect an agent from liability relating to COVID, but it would not indemnify the agent in the event of a suit from a client. An indemnity would cover the agent from all of the costs of mounting a legal defense, as well as being a bar to further action by the plaintiff.
Yeah, no, that's true, and that the order would be the order as I'm looking at it here. A person is not liable for damages resulting directly or indirectly from an individual being or likely being infected or exposed. So that's where the damages are, and it's limited to that. if you had to mount a defense, there may be costs that are involved, and you should consider that as you go forward.
Thanks, Jamie. So carrying on then, COVID has had significant impacts on contracts. What are key considerations for managing brokers and realtors to be aware of? A key reminder that I'll start with is that the underlying principles of contracts, agency, and disclosure still apply, and they still govern the relationship between parties. COVID has not made these disappear, so they should be the foundation when you're looking at various questions and issues as they arise, really focusing on what are the principles of contract law and how does that come into play. The rules haven't changed. We still have to comply with all regulatory rules in the same way that we did to prior to COVID. So Jamie, maybe you can provide a high-level overview of contract law.
Mm-hmm. So the general principles, as Karen's talked about, they really haven't changed, and really what that goes to is that the terms of the contract are going to govern the relationship of the parties. So whether it's a service agreement or a contract of purchase and sale or a lease, to determine what the rights and obligations are of the parties, you have to look at the language of the document that's been signed. And so in COVID situations, we've seen a lot of questions about what happens if I can't perform my obligations. So maybe a buyer isn't able to obtain financing because they've lost their job, or a seller isn't able, or a seller who has another purchase after may not be able to complete the purchase because their sale fell through. Or similarly, under a service agreement, a realtor is not able to provide an obligation or such that they'd promised to do because there are restrictions in place or some kind of a lockdown. In those situations, we need to look at how can the parties go forward and resolve this inability to perform, which is essentially a breach of the contract because they do have obligations there. The BCRA agreements, the standard form documents, do provide certain situations where the contract might be terminated, but that's not necessarily helpful because one, a COVID situation probably doesn't give rise to a termination unless it would meet the specific facts set out in the agreement. The other thing is that we've talked about is force majeure. We've heard a lot of people saying that because of force majeure, they wouldn't be able to perform their obligations. Force majeure is a contractual clause that's inserted in some contracts that allows a party to be relieved of the performance of an obligation in certain circumstances, usually unforeseen circumstances or something beyond the control of the party. And the contract would specify exactly what that is. That said, the BCRA contracts, the standard forms, don't have force majeure provisions in them. And as a result, that's not really a provision or a doctrine that could be relied on here. So these sort of unilateral outs aren't there in these contracts unless they've been added in or specifically negotiated. So we may have seen in contracts where some kind of a COVID clause has been inserted, there is some kind of a provision like that. But again, it would be a contract by contract determination, and you'd have to look at those specific clauses to see if they would apply. That's probably only going to have happened in a newer contract after COVID has come to the forefront. In an existing contract, again, we don't have the ability to just terminate at will or delay performance unless there's agreement between the parties. So really it comes back, this key fact is you wouldn't have the ability to unilaterally terminate an agreement. You would have to rely on negotiating between the parties to alter the terms of the agreement as they're written down.
Great. Thanks, Jamie. I think if I can jump in and talk maybe a little bit about, yeah, I think you did a great job in covering like sort of the contracts and contracts basically with clients. I thought maybe I could focus on the contracts between brokerages and the clients, so the written service agreements. Realtors and brokers, in helping stop the spread of COVID, we realize that they may not be able to fulfill all the aspects of the contractual obligations that they had entered into prior to COVID. But as we mentioned earlier, the rules haven't changed. So definitely there needs to be an open discussion with those clients on what options are available to them, and having them seeing if there's a mutual agreement to start amending those service contracts, or having them seek legal advice where appropriate. That legal advice, again, it can be documented on that notice and acknowledgement form, and while that form isn't mandatory, it was meant to be there to help reduce risk to real
on this thing?
and inform clients.
No, I can't get it.
It might also be a good time.
I know, I just wondered if you can, I took the plug out to get it on this, but.
Sorry, we don't have everyone on mute. Great, okay, sorry. It's also a great time for brokerages and realtors that haven't already done so to review those Schedule A's and see where there is areas of risk of where you might not be able to perform those duties. And in moving forward, when you're signing new service agreements, making sure that those Schedule A's are representative of the services that the brokerage will provide to the client. And I can't stress it enough that the written service agreements on the Schedule A are those that the brokerage will provide. So realtors shouldn't be amending those Schedule A's without consultation from their managing brokers and in conjunction with them. Amy, maybe I can turn it back over to you to talk about a little bit about frustrations of contracts.
Yeah, so where we aren't able to provide an obligation under an agreement, as I talked about earlier, the best case is to try and discuss between the parties what's going to happen and try to come up with a solution that's negotiated and agreed to and everybody's happy. In some very rare cases, and I say very rare because there's a very high threshold to get into this situation, if a contract was with regard to provide certain obligations that beyond the party's control, it is not possible to perform it, and it was unforeseen and really just wasn't able to, there's really no way around it. The contract may be in a situation that's called frustrated. And in these situations, the parties, one or both of the parties could apply to the court and have the court issue an order that the contract is frustrated and no longer can be performed. And there could be relief of obligations in that case. The problem with that is that it may not give you the outcome you're actually looking for because of the fact that it would essentially stop all obligations going forward, and it would provide relief. So really, it's something to keep in the back of your mind that frustration exists. However, it's such a high hurdle to get over, so it won't be applicable in all situations, and it may not give you the outcome you want, where a negotiated outcome may be better. I've seen a question, sorry, just come up. Have I seen any COVID-19 related frustration? I haven't, and I think part of the reason is twofold. One, it's the courts have been shut down except for emergency hearings right now, and so obtaining an order would be very difficult. And two, as I say, it's a very high hurdle to get over. So as a result, I'm not expecting to see a lot of it, especially since as we go on, because the more as we've been going on for now, say 2 to 3 months with COVID, being sort of the new norm, it's less and less unforeseeable.
Great. I thought I might use this opportunity to just talk a little bit about an area of risk that sort of has come up or come onto our radar, and it's you know, I would say that in my experience, realtors are very generous and really wanting to help clients. Probably now more so than ever. They're trying to repurpose. They're trying to definitely trying to appease. It's a difficult time for everyone. But sometimes in doing that, I think that they're putting themselves in great risk when they're acting outside of their area of expertise. So we've recently been made aware that realtors are trying to help clients in trying to offer additional types of services, and that could be property management or related services and stuff like that. And we would just really strongly encourage realtors just to remember that you can only provide real estate services that you're licensed for. So the other area of risk that we're starting to see cropping up is in terms of like the virtual showings, virtual live open houses, and some realtors expanding their geographic area, given that these virtual tools are in place, and diversifying their business of selling properties into these areas, which may not be in a realtor's area of expertise, or realtors may not have actually physically viewed the home, and so the risks that are associated, again, with this can be really significant. So just considering the options of referring or trying to mitigate some of that risk that might be out there.
Thanks, Jennifer. And another consideration around risk is privacy law. And it's even more relevant during these times as information is stored on the cloud. And that might be outside of Canada. Sellers are using their phone to show you around their house. Online chat software is being used to present offers. We have services like DocuSign and AuthentiSign that are being used to sign contracts. What key considerations do managing brokers and realtors need to be aware of as it relates specifically to privacy law? Jamie, maybe I can ask you to give us an introduction to privacy from the legal perspective.
Sure. So in BC, we're looking at the Personal Information Protection Act, and the underlying principle there is that if you are going to be collecting, using, or disclosing an individual's personal information, you really need to have consent. And so BCRA documents or standard forms do provide for consent in sort of the common real estate transaction situations. And it's both in the service agreement, in the consumer agreement, so the contract to purchase and sale, for example, and it's also in the privacy notice and consent form, which most, if not all, realtors are getting signed sort of at the outset of the transaction. So again, it's one of those tools that's available to help guide the conversation of how personal information is going to be collected, used, and disclosed by the realtor collecting it, and how it's going to be used by others that the realtor may be providing the information to, for example, to the boards. Really, this is an ongoing discussion that you're going to be having with your client throughout the transaction, and you'll update it as things change and as necessary, and continue to have that consent. So they're informed of what you're doing with the personal information and how you're using it.
Absolutely. I'm going to touch on something that Karin had mentioned earlier, and it's just that the privacy laws, they haven't changed. So while business is adapted, there's lots of key considerations now to working remotely, which realtors were doing a bit in the past, but some of the new virtual tools being used, and I thought maybe I would just touch on some of those. So the virtual tours were really in order to follow social distancing guidelines. So we've been seeing more and more virtual showings and virtual tours, which have some great benefits, definitely, in terms of reducing the potential for cross-contamination in properties, while really allowing buyers to view those homes in the comfort of their own home. So pajama viewings, I think. In terms of privacy considerations, definitely there's been some similar discussions to the ones that you probably previously have already been having with your clients and stuff like that, in terms of like putting private information away. So you don't want to leave your mortgage documents necessarily on the kitchen table, and especially while somebody's maybe in and videotaping the showing. You know, suggesting to sellers that they might want to remove personal information, personal photos, expensive artwork, but that really hasn't changed. Buyers, realtors should be obtaining permission from the seller through the listing realtor in advance of conducting virtual showings of the home. So definitely before you go in and start videotaping a home to do a virtual tour, you really need to make sure that you're having those conversations with the listing realtor and you have that permission. And definitely when talking to buyers, just ensuring that they're aware and they understand that virtual tours aren't meant to replace physical showings. They're meant to reduce maybe the number of homes or limit the number of homes that a buyer might want to see. But there's significant risk in purchasing a home sight unseen or just seen on a virtual means. The live tours, definitely something that may not be new to everyone, definitely more new to me. It really allows clients to participate in a conversation and a showing. So you've got the buyer's realtor, the seller, and the seller's realtor, all on some form of platform. The seller is doing a walkthrough of the home, they're videoing the home, and the buyer, through the buyer's realtor, is really directing them as to what it is that they want to see. So zoom into the living room, can you show me this? Can we go back in? Can I see the closet? Well, these types of tours are sort of similar, or you can take them back to sort of like the lockbox tour of where the four parties meet and they go through the house. Sorry, the seller wasn't usually there, the listing realtor, the buyer's realtor, and the buyer. You know, those conversations of when the buyer is going to meet the listing realtor, making sure that they are keeping that personal information confidential, and really limiting what kinds of questions do you want to ask and are appropriate to ask. And those are really important aspects in those virtual showings as well. In terms of risks around those, definitely, obviously, like private information is not so private when you're on a platform with the other parties. And whatever platform you're using has their own privacy provisions, so making clients aware of that as well. The recording and use of the video, so as Jamie had touched on, like, how are you going to use it? Who's it going to be shared with? And just again, the fact that some of that personal information may be conveyed to that other party depending on what the platform is being used, such as maybe the user ID, maybe an email address, or some other contact information. The other one that Karen had mentioned that I wouldn't mind touching base on is the electronic signatures. So just a reminder that when you're placing initials and places for signatures, depending on if you, in some electronic programs, e-signature programs, if you are ordering how they see it or just sending them out, sometimes those changes are not visible to all parties. And so that we kind of think is a bit of a significant area of risk if a party isn't really seeing what it is that they're signing, and the potential for them to say, oh, I didn't know that these changes were made, even though the other party signed it and their signatures would appear. So this may be a great opportunity or a great time to sort of test those programs and test the ordering functions and test the free functions in terms of, you know, what can be seen when there's modifications to contracts, and just making sure that you have a similar experience. And you're also having conversations with the clients about what those changes are. And then just storing information on the cloud, so just ensuring you obtain consent, and there is some consent, as Jamie had mentioned, in the service agreements. But just being really aware of where that information is stored when you are storing on the cloud, and how it's being stored, so that you can have those meaningful discussions with clients.
Thanks, Jennifer. Those are some great points. When we go past privacy law and we start talking about disclosure requirements, what do we need to know about disclosure during COVID? Jamie, maybe if I can hand this to you to give us your thoughts.
Mm-hmm. So much like underlying fundamentals of contract law and privacy law, the disclosure requirements remain the same, in that a seller would still have the obligation to disclose latent defects as defined in common law. A realtor still has the obligations under the real estate rules to disclose the defined material latent defects. And then we should also consider whether the rules regarding stigmas and how proper due diligence should probably be done around stigmas, but there may not necessarily be disclosure requirements. The big one that's going to affect realtors is really material latent defects, because it comes up under the rules and whether they have disclosure obligations. And people are asking, well, is a COVID-19 infection a material latent defect that must be disclosed if someone's been in the property or has been recovered at the property? And it's not an easy answer necessarily, because there's so many different factors, and as COVID-19 is quite new, we don't know whether there are lingering effects on a property. I think the key in that situation would be to take the specific facts and get legal advice as to whether disclosure would be appropriate or required.
Absolutely. I would say in BC, with the stigmas regarding properties, it really isn't a disclosure requirement of the seller or the listing realtor. But from a buyer's agent's perspective, definitely having that conversation of, is this something that would impact the buyer's decision to purchase, and what kind of due diligence they might want to do around that, would probably be really important for them to address with clients, just to ensure that they are representing the client's interests, and to make those inquiries of the seller as appropriate or as required. Under common law, as Jamie said, is MLD a latent defect, and unfit or unsafe for habitation? We don't know the answer, and given that, if a seller is queried on it, seeking legal advice is probably really in their best interest, and it's okay for realtors not to know the answer to this, but telling them to get independent legal advice is so important. Karin had mentioned earlier in the session about the resources that BCREA has created on their BCREA website, and in terms of the COVID portal. And one of those resources that I just really wanted to highlight as we're talking about disclosures and contracts is the Standard Forms COVID Disclosure and Contracts FAQ. And those were really informed from managing brokers and realtors around the province as they had questions, as they were looking at things. They've been legally reviewed, the responses to them. We are updating those FAQs on a fairly frequent basis. It seemed like it was every 3 days in the beginning, and now we're down to sort of on an as needed or as information changes. So I would definitely encourage you, if you haven't already seen the resource, to go and check that out. And if there's a question that just hasn't been addressed there and stuff like that, please feel free to reach out to Karin or I, because we definitely want to make sure we're supporting you in practice around the Standard Forms.
Thanks, Jennifer, and I'll certainly echo those comments. We're always looking for more questions to include. If it's something that is on your mind and we can provide an answer, we'd love to have it in there, because if you've got the question, I'm sure lots of other agents do as well. Over the next while, BCREA will be working on figuring out what the next steps are in what our hopefully new normal is going to be. Premier Horgan is making an announcement this afternoon, and we hope that that's going to be some softening of the regulations. We know it's certainly not going to be a full opening, but really understanding what could this look like for brokerages, for agents, and for ourselves. And over the next while, we will be collaborating with a number of industry partners to provide some guidance on how to reopen offices and resume services in what we're terming as the new normal. So do stay tuned for that. As soon as that resource is ready, it will be part of our COVID-19 portal. So please do pay attention to that. So at this time, I'm going to open it up for any questions that you might have. You're welcome to put them into the chat box, or you can unmute your mic and jump in. Any questions that are within the scope that we don't get to or we aren't able to address today, we will take them away and add them to the resources we've been talking about, and we can get back to you as well. I'm going to put a slide up with our contact information so you can reach out directly. So we do have one question in the chat. Some realtors are requiring buyers, realtors to complete waivers before showings. What should I do in such a case? So maybe Jamie, we'll start with you and we can get Jennifer to add some practice considerations as well.
Sure. I think the key is it depends what the waiver says. And it's probably a good idea to consider what it says specifically and consider the implications. So if a waiver, the effect of a waiver is going to be that you're releasing or waiving some kind of liability, and you now have to think about what risks you're now taking on yourself or taking on for your clients. So it goes back to my comment earlier that it's probably important that if someone's going to give you a waiver or some kind of a clause that's going to affect liability or risk, you should be getting advice from legal counsel prior to signing that.
Thanks, Jamie. Jennifer, did you have anything to add? I'm not seeing Jennifer there. Okay.
Can you hear me now?
We can, yes.
Sorry. So, sorry, I was just echoing Jamie's sentiments on that. Is just really thinking through thoughtfully, what is the waiver saying? Should you be having a client sign it? And seeking legal advice where you're unsure of it, because there are some waivers there that are definitely in the favor of realtors, or, you know, and who's asking for the waiver to be signed? Is it something that you're requiring? Is it something that the client is? And just making sure that you're having those meaningful conversations. But when in doubt, definitely seeking legal advice.
Thanks, Jennifer. Do we have any other questions? I'm a seller who's receiving an offer to protect my seller with any risk due to COVID. Would you suggest to add a clause to say seller to add two clause to get legal advice regarding the contract before accepting the offer? Jamie, your thoughts?
I think it depends. It depends, again, what that clause says. And one way to deal with it would be to say that the seller's acceptance is subject to obtaining legal advice, and that could work. The other way to do it would be to try to get the clause vetted ahead of time, and the advantage of that is that you may not have to reopen negotiations on the offer and change terms. So hopefully that sort of helps as two thoughts on how to go about that.
Thanks. Anything to add, Jennifer?
No, I think that summed it up pretty perfectly.
Perfect. Do we have any final questions? I'm not seeing any more in the chat or any hands. Okay, so that looks like that's all the questions that we have for today. So thank you so much for your time. We appreciate you joining the conversation today. And feel free to reach out. You did have our contact information. I'll put it up again briefly here. Feel free to reach out, and all the best out there, and stay safe. So thank you, everybody, and enjoy the rest of your day.